Good morning. Please be seated. All right, we're here in the Cineworld case. It is 22-90168. Electronic appearances should have been made. Let me find out where we are today in terms of what presentations that we need to get done. Mr. Sussberg, I'll let you take the lead and bring me up to speed.
Yes, good morning, Your Honor. Joshua Sussberg from Kirkland & Ellis on behalf of Senators. Can you hear me okay?
Yes, sir. Thank you.
Thank you, Your Honor. We have two matters on the agenda today. Item number one, which we intend to take first, if it's okay with Your Honor, is authorization for Regal to enter into a new screen advertising agreement with NCM. And the second matter relates to a request for the appointment of an equity committee. As it relates to NCM, Your Honor, if you're prepared to entertain that first, I think Your Honor is well aware that Judge Jones heard NCM's motion to enter into the same agreement yesterday. He found that entry into the agreement was appropriate. He did not find that the MFN was triggered, and he refused to grant 363M relief, as he did not believe that the applicable sale provisions applied under the circumstances. As we sit here today, Your Honor, we have two objections with respect to our entry into the NCM screen advertising agreement. Those are from AMC and Cinemark. Likewise, AMC and Cinemark objected yesterday. They argued that the MFN was triggered, which Judge Jones again found was not the case. And they argued that 363M was inappropriate. They are likewise, in our case, arguing the inappropriateness of 363M. And before we run up the hill, Your Honor, and argue on that provision, wanted to take guidance from the court as to whether or not Your Honor believes Judge Jones was correct. And if so, I think we can proceed on a more limited basis.
I actually don't think that I should express a view on whether Judge Jones was correct or incorrect. I think I am bound by his ruling under res judicata principle, same party, same issue. And so with respect to the 363 issue, frankly, I don't think it is even an issue in my case. It is an issue in the NCM case. With respect to whether it violates the MFN, that again is an issue for the NCM case and not an issue for the Cineworld case. All that I have in the Cineworld case that I think I should be taking up is whether this is an appropriate exercise of business judgment. But otherwise, I think I'm just bound by what he said. Having said all that, I don't disagree with it. But I don't think I'm supposed to agree or not agree from a practical point of view. I think it's just binding. I mean, so I'll listen to arguments otherwise.
Well, Your Honor, what I would intend to do, and how we should proceed if it's okay with the court, is Ms. Foster will put a presentation on the record that demonstrates that we do in fact satisfy the business judgment by any stretch of the imagination with respect to entering into the new screen advertising agreement. And we would simply remove the 363M provisions from the proposed order and make life easy for the AMC and Cineworld folks today, because I don't think they'll need to appear as a result.
Well, if anyone from AMC or Cinemark wants to appear, it's fine with me. And if they think I'm wrong about this, but I think I'm bound by the ruling. So I'm inviting them to appear and to disagree with what you want to do. But we'll see what they say. Morning.
Good morning, Your Honor. Christian Gluck of Norton Rose Fulbright with Julie Harrison on behalf of Cinemark. We don't take issue with the proposal this morning to move forward. We're pleased to hear that we're not going to be re-arguing that today. I think we did review the order, and so we would certainly like to have some view. There's more than just one sort of 363M provision in the order, so we just want to make sure that those things are excised from that. And other than that, I think we can sit down and listen to the remainder of the hearing.
Thank you.
May it please the court, Your Honor. John Cruciani of Hush Blackwell for AMC, and we concur with Mr. Gluck's comments and believe that's an appropriate way to proceed. Thank you.
So as I understand it, we have no party that objects to the relief so long as it conforms to Judge Jones's ruling yesterday. And with that, I will let you put on what evidence you wish on the business judgment rule on a matter with which I am intimately familiar. Mr. Sussler.
Thank you, Your Honor. I am going to turn it over to Ms. Foster, and I think we are going to be very, very brief in demonstrating that we satisfy the business judgment, as we do know Your Honor is intimately familiar over the course of the better part of 9 months of this matter. So thank you, Your Honor.
Thank you. Ms. Foster, can I get you to press 5-star one time on your phone, please? Good morning.
Good morning, Your Honor. Kira Foster, Kirkland & Ellis, counsel to the payroll debtors. Are you able to hear me okay?
I can hear you fine. Thank you.
Thank you, Your Honor. So before I move to discussion of the motion, I just wanted to flag for Your Honor that we filed a declaration about an hour ago for Mr. Mesterholm, who's also here at the hearing today, at docket number 1871. I just request respectfully that we move that declaration to evidence.
Is there any objection to admitting Mr. Mesterholm's declaration that was filed at 1871? Do you have one party? Hold on. No, I'm wrong. That was still you seeking to speak. Let me read it, and then, because I had not seen it. So give me just a moment. All right, without objection, the declaration filed in 1871 is admitted.
Thank you, Your Honor. Your Honor, as previously by Mr. Sussberg, we're here today to seek approval of the agreement to two agreements. First, the termination of the lease agreement, which terminates all other existing relationships between Cineworld and NCM, as well as releases both parties. Second is the affiliate transaction agreement, which relates to the provision of screen advertising services. Additionally, we're also seeking a finding in our order that the existing ECA, as we term it in our motion, is rejected as well. Your Honor, we worked with the parties other than AMC and Cinemark. We've received no objections to the relief we're seeking. We previewed the relief with both the U.S. Trustee's Office, and we have the affirmative support of our lenders as well as the committee. Unless Your Honor has any questions, we would respectfully request entry of the order.
Thank you. Is there any additional evidence in support of entry of the order? Is there any additional evidence in opposition to entry of the order? All right, I'm going to put the order up on the screen and try and see what we need to do to be sure that we are conforming with the ruling yesterday in the NCM case. Is that showing up for you, Ms. Foster?
It is, Your Honor.
So I've made a number of changes to the draft order. I may not have made all that are required. Let me start by objections from the debtor as to whether I've impaired what they expected to do, and then we'll take it from the parties that have objected. Ms. Foster?
Your Honor, no objection to the debtors.
Okay. Mr. Glock, do you want to take the lead?
Thank you, Your Honor. So we started, Your Honor, with the tail at the end of paragraph 1, Your Honor. So it was respect to the discussion of purchase of advertising services and sale.
I'm sorry, I thought you said the end of paragraph 1.
Well, the end of the second to last sentence in paragraph 1, it says sound business purpose and justification for the purchasing and sale. I mean, it was pretty clear that there was no purchase, there's no sale. We don't want this to be a backdoor into 363M. I mean, we don't have any issue with a sound business purpose and justification for entry into the agreements, but the color of purchasing and sale.
Ms. Foster?
Your Honor, we're comfortable with that.
All right.
Okay. Can you scroll down to 2, Your Honor? I want to make sure that we covered our concerns in that paragraph as well. Good faith. Good faith. Good faith. You think that's fine? Yeah, I think we're fine with 2, Your Honor. Then the next comments we had, Your Honor, were in paragraph 6. And I think you may have covered them, but let's just confirm.
I think it's the same
Oh, that's the same concept. That's right, Your Honor. And then I think on 7, Your Honor, the concern we have, we don't have an issue with the acting in good faith, Your Honor. That's what Judge Jones said. But I guess we want to make it clear that under applicable law, just making sure that one of the applicable law that's not applicable is 363M.
I'm not expressing a view about that. Right? Judge Jones has said what he said. I'm not altering what he did, but I'm not understanding what your concern is, and that if he is correct, then applicable law would not include 363. But if he is wrong on appeal, then applicable law might very well include 363. So I'm trying to not characterize what's happened. I've done, I think, the other things you've asked. But I don't know what happens on appeal. So assume for a minute with me that you lose on appeal. I doubt there's going to be an appeal. Assume that you lose on appeal, and that this, in fact, was a purchase and sale entitled to 363 protections. They get them.
Sure.
But I'm not going to determine whether it does or doesn't. I'm simply not altering his findings. It'll be up to an appellate court to do that.
Right.
So I'll overrule that objection.
That was it, Your Honor.
That was it?
That was it.
All right. Any other party want to voice any objections? Okay. I've signed the order. It will be docketed by Ms. Thomas this morning. I believe that concludes the debtor's motions, and we should now move to both the letter request for a shareholders committee and the emergency motion filed by Mr. Sather, and let them take the floor. Mr. Sather, I want to start by finding out whether your motion supplants and replaces the letter. I don't know if that person who sent the letter is a member of your committee, for example.
Stephen Sather for the ad hoc committee. Yes, our motion is intended to supplant the pro se filing that was made earlier.
All right, then, unless anyone wants to pitch in and disagree that that's what Mr. Sather is doing, we're going to give him the lead to argue why there should be and to present evidence as to why there should be an equity committee.
Yes, Your Honor, I just wanted to introduce myself, Gavin Campbell of Kirkland and Ellis, on behalf of the debtors. I will be handling this motion for the debtors.
Thank you, Mr. Campbell. Mr. Sather?
Yes, Stephen Sather and Charles Murnane for the ad hoc committee of equity holders. We filed our witness and exhibit list at docket 1855. I would move the admission of exhibits 1, 3, 7, 8, and 12 to 20. These are all filings by the debtor and therefore are party admissions.
No objection, Your Honor.
Just looking for it. Hold on. All right, 1855, 1, 3, 7, 8, 12, 13, 14, 15, 16, 17, 18, 19, and 20 are admitted.
Would also ask the court to take judicial notice of 1855, 9 through 11, and 22 to 25. These are all submissions by the equity holders in this case. I'm offering those merely to show that the equity holders have been seeking a seat at the table in this case.
Your Honor, we have no objection to the judicial notice of the fact that these were filed, but obviously we reject any introduction of the contents or the truth of the matter asserted. I don't think Mr. Sather is saying anything contrary to that.
I think that's right. 9, 10, 11, 22, 23, 24, and 25 are admitted solely for the purpose of notice that shareholders had not been silent in the case and have sought various forms of relief, and not to any of the factual statements made within those exhibits.
All right. Thank you, Your Honor. We are here requesting appointment of an equity committee. The benefit of having a committee is that you have a seat at the table, and as the saying goes, if you don't have a seat at the table, you're on the menu. And in this case, the debtor is proposing to wipe out equity in the plan, and although we are arriving rather late in the process, we believe that formal participation by the equity holders would bring a benefit to the case. Under the Pilgrim's Pride test that we cited in our motion, there are 6 factors that the court should consider. The first is whether the debtor appears to be hopelessly insolvent. The second is the complexity of the case. The third is whether the stock is widely held and actively traded. D is whether the interests of the shareholders are otherwise adequately represented. E is the timing of the request. And F is whether the cost of the additional committee significantly outweighs the concerns for adequate representation. Now, turning to these steps, or these areas, in showing the solvency or insolvency of the debtor, the ad hoc committee is somewhat hamstrung in that it has not had the resources to conduct an independent evaluation. But what we do know from the debtor's first day declaration, which is our Exhibit 3, and if I may show my screen.
Do you want to show yours, or do you want me to just show mine?
Oh, showing yours is fine, Your Honor.
Just generally a little easier for you. Thanks.
Thank you. If we go to page 8 of the first day declaration, what we see is that the debtors were experiencing regular growth in income, and then they were hit by the COVID pandemic. And I think the court can take judicial notice that the COVID pandemic has passed as declared by the United States government. The next factor I'd like to show is in the debtor's April monthly operating report at Exhibit 17. If we go to, excuse me, and this is for the U.S. Operating group. We show that, and if we go to page 2, excuse me, we show that the debtors did make a profit during April, despite having lost quite a bit of money earlier on in the case. And then next, if we go to the debtor's valuation report, at Exhibit 8, the disclosure statement, going to page 141. What we see is there is an enterprise value predicted of approximately $3 billion. However, what we have in the disclosure statement and in what was provided to creditors is a summary of a valuation without any of the underlying data. And so, given the limited information that is available to the creditors, believe that the debtor is not hopelessly insolvent. As to the
I'm kind of missing. What's that belief based on? I mean, I understand that you may not have information to form a belief, but I don't understand how you have formed a belief if you're telling me you don't have the data to form a belief. So try and clarify that for me.
Certainly. The equity holders believe that there is solvency, and they have requested permission to present an alternate valuation to the court, and Your Honor has entered an order requiring them to present that at the hearing on June the 28th. But at this time, it is a belief rather than something that we can support with verifiable evidence before the court today. So what we know from the filings that we have is that the debtor's business was increasing. It hit COVID. The debtor is now showing at least some profitability, and we know that we are on the other side of the COVID pandemic. Now, we also know, based on the information provided by the debtor, that there is a large delta between the going concern value of the debtor and the liquidation value of the debtor. In the liquidation analysis, they put the liquidation value at between $400 and $600 million, whereas the going concern value is in the $3 billion range. And given numbers of this size, I believe we have at least some reason to believe that the debtor is not hopelessly insolvent.
Well, maybe that means, I think that your interpretation of hopelessly insolvent and what I believe the law's interpretation may be different, and I want to spend a minute going into that. I don't believe that you can prevail based on a belief that in a few years the debtors could work their way out of an insolvency. I think hopelessly insolvent deals with what is the current situation, i.e., do they currently have fair market value assets in excess of the debt? Or maybe alternatively, is there a feasible plan that could service the existing debt in order to get them to that period of recovery? But given what I've seen, I don't see how they'd possibly service at market $6 billion worth of debt, which means, I think, and we had a market test of what it will bring currently, you've got to challenge that market test or correct what my view of hopelessly insolvent means.
Yes, and in our moving paper, or our motion, moving paper sounds pretentious. In our motion, we've cited several examples of cases where the debtor appeared to be insolvent, but the court appointed an equity committee nevertheless. And I believe that hopelessly insolvent should be construed to mean that there is no set of facts under which the debtor could possibly be solvent, and that there could be...
So what is the set of facts under which they're solvent?
if we take a forward-looking view of the debtor finances, one which takes into account the improvement in 2023 coming out of the COVID pandemic, there is every reason to believe that the debtor either is solvent or will become. And that's really the catch-22 that we have.
Yeah.
We want to be able to present a valuation to the court, but the individual shareholders do not have the resources to do so on their own. If you are a shareholder who has invested 70,000 pounds in the debtor's stock, as one of our members has, you can't afford to spend $70,000 on a valuation.
So when would this valuation be available?
I am told, and I will have one of my committee members available to testify, that we have the valuation expert lined up, and we would hope to have it to present on June the 28th, as the court has required.
What do you think that's going to cost?
I don't know, Your Honor. Mr. Grama, do you know what the report is going to cost? This is Eunice Grama, one of our committee members. He is appearing from Romania, Your Honor.
Right, Mr. Grama, if you could press 5* one time on your phone, please, sir. Just hold on, don't. I've got you, and I now need to activate your line. He may have pressed it again. No, there we are. All right, Mr. Grama, good morning, or good afternoon to you.
Good morning, everybody. Good to be here. Thank you very much.
So, Mr. Grama, do you know about what the cost is going to be of the valuation that's being discussed?
We have learned about my work. We have reached out, just like we have reached out for potential legal counsel lately, and we finally managed to retain one in the end. So now we tried to balance the market again. The simple disclaimer, we are kept the world is not act as a unified body. We have to look at the formal way of, let's say, addressing the parties. So we are...
Mr. Grama, I'm going to interrupt you only because your voice is a little foggy, and it may help if you pick up the phone.
Okay, I'll do that. Let me know if it's any better.
I think that is better. Let me ask. I'll take this a little differently. Would you raise your right hand, please, Mr. Grama? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Sather, let's try and get an answer to that question.
All right.
I'm not going to preclude you from presenting the rest of your case. But
Thank you. Mr. Grama, have you consulted with a valuation expert to seek an enterprise valuation of the debtors in this case?
So then the opinion of the expert, from personal reasons or professional reasons, this expert, the one that we can do constantly do, he wants to forward, and he wants to get himself, but to the same new person as a property.
so I can't understand him. Please pick up the phone.
Hello?
Yes, if you could perhaps slow down a little bit and speak more clearly.
And take us off the speakerphone, please.
Hello?
Go ahead, Mr. Sather.
All right.
So when a same individual acting as a proxy, we have been able to research the market because he's connected with the industry, and we have been reassured that should we have the possibility to pay such a fee, which again is not yet determined, but we can determine rather quickly if we get the hint or the confirmation that on such funds will be available. So we can produce a report within the time frame that is remaining until the hearing on June 28th.
All right. And how much will you have to pay to get the report?
We don't have this information yet. A rough number that has been, let's say, moved around, it's in the area of $150,000. But again, this is not something that we have for paper.
All right. So I heard $150,000, Your Honor.
I couldn't understand what that was about, though, just so you know. I did hear that number, but I don't know what it meant.
Mr. Grama, did I hear you correctly that you estimated the cost of the report at being $150,000 US?
Correct, from top informal discussions that we had, but without getting this figure pinned down in a formal offer.
So I'm simply not understanding the words, and I don't know how you want to confront that, but I'm not understanding them. So it's up to you to try and deal with that.
Okay. Well, let me see what I can do. I do understand that his accent is a little bit difficult to...
Right, and I'm not complaining about that, but in order for it to be evidence, I'm going to have to hear it.
Okay. So...
Let me try to do it again.
All right. Please try again, Mr. Grama.
Okay, Jim, first of all, please confirm that you hear me now.
I can hear you. Yes, I can hear you. I don't know whether the judge can understand you. But if you could just speak as...
Your Honor, am I audible to you, Your Honor?
I'm able to hear you. I wish you would use that like a regular phone, and I think I can hear you better.
On my iPhone, and it's usually working fine.
Like this, like a phone is held.
Yes,
Right. I think I'm going to hear you better that way. But let me get you to ask a question, Mr. Sather, and then we'll get Mr. Grama to give an answer.
All right. Mr. Grama, do you have an estimate of $150,000 US in order to obtain the valuation report you would need to show that the debtor was solvent? Yes or no?
Yes.
And yes or no, if an equity committee is appointed, do you believe that you will be able to obtain this report in time for the confirmation hearing on June the 28th?
Yes, we will hope so.
And this is, I don't know if the court wants me to limit this to the matter that we were discussing.
I'll leave that up to you. I'm going to let Mr. Campbell ask cross-examination questions on that particular matter or on more if you want to do more now. But I'm also going to allow you to call Mr. Grama later if you want to call him later. So.
Okay, I think as long as we've started his testimony, why don't I proceed?
That's fine.
Mr. Grama, can you tell the court how long you have been a shareholder of Cineworld?
Your Honor, relevance grounds here.
Relevance.
Hello?
Hold on a second. We have an objection to the question. Mr. Sather.
I did not hear what the objection was.
Relevance.
Relevant. I am introducing simply introducing the witness.
Sustain the objection.
All right. Mr. Grama, do you have personal knowledge as to whether the stock of Cineworld was publicly traded at the time that the bankruptcy case was filed?
Yes. And yes, it was.
And have you continued to trade in the stock of Cineworld while the bankruptcy case has been pending?
Objection.
What was the objection, Mr. Campbell?
All right.
Objection.
One of the
Hold on.
elements...
Overruled.
Okay, thank you. All right. Have you continued to trade in the stock, sir?
Yes. The main reason being that by the time, so to your first question,
No,
I ended up in stock.
stop. The answer was yes.
All right.
Next question.
And you have been somewhat vocal in trying to obtain representation for the equity holders in this case. Why do you believe that the judge should appoint an equity committee?
I'm going to make my own objection. Sustained.
Okay. Mr. Grama, what benefit do you believe that having an equity committee in the case would bring?
Objection calls for speculation.
Sustained.
All right, let me... Mr. Grama, as an equity holder, do you object to your interest in this debtor being wiped out?
Yes.
And why do you object?
Objection, Your Honor, that would be a confirmation issue. Objection.
Overruled. Go ahead.
All right, you can answer the question, Mr. Grama. Why do you object to your equity being wiped out?
I think the answer was already in the previous, but I can double on that. It is because mainly we have the conviction, not belief, we are sure that Cineworld is not hopelessly insolvent as it was presented in the case, and particularly in the valuation in the case. I would just start to consider as lack of foundation in popular opinion.
Sustained.
Okay. Mr. Grama, do you have the means to pay for a valuation out of your own resources?
Me personally, or us, the individual shareholders of the group?
All right. You and the other two members of the ad hoc committee.
Here, and to mention, we represent more than 100 people. We have an open registry with names, holdings, and so on. So are you referring to the 3 of us, to the 100 of us, or to the 3,000 out there in the market, please?
No, I'm referring to just the members of the ad hoc committee. Or let me just ask it much more narrowly. If you had to pay, do you have the resources to pay $150,000 for a valuation of the debtor?
I would like to answer the question before I go to a statement. Has anybody in this chapter level paid for the council or any type of services from their own pocket? And then, just your question. Answer.
Sustained.
All right.
Sustained. You need to answer the question.
Mr. Grama, just trying to
And then your,
find out
your
whether...
question.
Yes, well, I'm
Just
just...
your question.
Sure.
According to what the price of the evaluation would be or would be, I would probably be able to do it, or it would be a huge amount of effort for me personally.
All right. And so, if you were part of an official committee and had the ability to hire an expert, would that assist your ability to bring the alternate valuation before the court?
Objection, Your Honor, calls for speculation.
I don't believe so, Your Honor.
Overrule. You can answer.
All right.
If you could repeat the question.
Yes. Would having an official committee enhance your ability to bring an alternate valuation to the court?
As I understand, equity committee's actions to a certain extent are funded from the estate. So from that angle, I would say that definitely yes.
All right. And I'll pass the witness.
Thank you. Do you have any questions, Mr. Campbell, for Mr. Grama?
Yes, sir. Yes, sir, I do. Mr. Grama, can you hear me all right?
Yes, please.
Mr. Grama, what is the identity of the expert who has quoted you a $150,000 figure?
I cannot disclose it.
Why is that?
Because I don't have a permission from the respected expert.
Your Honor, can I compel the witness to answer that question? That's not a privilege objection. That's not a relevance objection.
Mr. Sather?
Yeah, I don't have a good response, Your Honor. Other than if the individual is not authorized his name to be publicly disclosed, I guess it's not a privilege.
So, I want to tell everyone what's going through my mind to try and figure out how we approach this problem. If we appoint an equity committee, and so far I'm not really seeing that we will, but I'm not discounting that as a possibility. I'm not going to pay an expert unless they come up with a Daubert qualified opinion. So I'm not just going to give somebody a check and then see what they come up with. It has to be Daubert qualified. It doesn't mean that it has to be the winning opinion, but it has to be Daubert qualified.
Correct.
And I don't want to mislead somebody that might be expecting to be paid by saying, I'm going to pay whoever it is without knowing who they are and without knowing whether they're going to be able to give a Daubert qualified opinion. So it's somewhat of a problem for your committee and a chicken and egg problem. And I don't know how we ought to approach it. I'm not trying to destroy confidences that Mr. Grama might have with someone, but he's testified what somebody told him that. I think it's a legitimate area of inquiry, but more importantly, it's a critical component of what you're trying to do. So
Right.
let me let you respond to that. Or
yeah, and certainly,
no, I need to talk to your lawyer about it. So go ahead, Mr. Chairman.
certainly for a committee to hire a valuation expert, we would have to submit an application to the court disclosing not only who the expert is, but his qualifications.
Right, we only have 12 days to start and finish this whole process.
It will be challenging, Your Honor.
Yep, so that's why I'm throwing this out to you right now. I don't want, the worst thing I could do would be to say, yeah, let's have a committee, y'all go out and go into a lot of work, and then I reject the report and don't pay that person. And I think that would be just wholly unfair. So that's why I'm worried about this, and I'm going to hold the objection and the motion to compel and see if it matters in the end. Go ahead, Mr. Campbell.
Excuse me, Your Honor, I said I'm happy to proceed with some questions. We'll get at the same issue without perhaps getting into name.
Go ahead.
Mr. Rama, is the proposed expert that you are considering an individual or a member of a broader firm of some sort?
We would be engaging with well-known, reputed global companies in order to do this for us.
And I believe you said global companies, plural. Do you mean just a single company, or have you gotten a quote from multiple companies?
We will go for the biggest names that are involved. Yes.
And
by no means would that be an individual or an unknown party.
to be clear, have you received a quote for a $150,000 valuation from any major valuation firm?
Informally, yes. In order to get to a heated discussion, we have to show that we are ready to get some backup, financially speaking, which we haven't. So in our over-the-table discussions, yes.
So just to be clear, Mr. Brown, is your testimony that you have a quote for a $150,000 valuation from it?
We don't have a quote, we have the information, but the price is being disputed.
I just asked if you could just let me finish the question that I had, Mr. Brown. My question was, do you have a quote for a $150,000 valuation report from a large valuation firm?
No.
The $150,000 quote you received, is that from a large valuation firm?
No.
When the $150,000 valuation was provided to you, was that offered at a flat rate with a cap, or was that an estimate of hourly or some other type of movable fees?
It's more of an estimate, and I don't know the details of how the price was structured or would be structured.
So you do not have any commitment that the valuation would be limited to $150,000 from any firm?
No, not at the moment.
Do you have any quote for legal counsel fees in connection with preparing the valuation report and offering valuation evidence and confirmation?
Again, not yet.
Those are all the questions I have for Mr. Grama, Your Honor.
Thank you. Anything further from Mr. Grama? Mr. Sather?
No, Your Honor.
Mr. Grama, thank you, sir. All right, Mr. Sather, go ahead.
All right. We were discussing the elements, and obviously the most difficult one is whether the debtor is hopelessly insolvent, which we've spent some time on, and that is the chicken and egg question, which the court referred to. The complexity of the case, this is certainly a complex case. The stock is widely held and actively traded. That's established for Mr. Grama. There is not anyone representing the interests of the shareholders in the case. The timing of the request does weigh against us since we're coming in at the 11th hour. And the court can take judicial notice of the fees that have been incurred in this case in the millions and millions of dollars, and the cost for an equity committee would be de minimis in comparison to the remainder of the fees. I would add that if an equity committee was appointed, our firm would be willing to represent the equity committee. Obviously, they would have to hire us, and we have no guarantee of who would be on the committee or who they would choose as counsel. But I suspect that our fees would be very affordable in comparison with the fees that have been incurred in this case to date. Certainly, we would be working within a short period of time, and our hourly rates range from $300 for associates, or $350 for associates, to $550 for myself.
Mr. Sather, thank you. Is there any other evidence that any party wishes to introduce in support of an equity committee?
Not from the ad hoc committee, Your Honor.
Thank you. Mr. Campbell.
Your Honor, I would, before offering any evidence of our own, I would seek to move under Rule 52C of the Federal Rules of Civil Procedure for a judgment on partial findings. I've incorporated through Rule 7052 and 9014 of the Rules of Bankruptcy Procedure for failure to meet the evidentiary standards to appoint an equity committee. I'm happy to go through some points or just entertain that motion right now before we present any evidence, Your Honor.
I'm going to deny that because right now I don't have in the record the solvency issue from either side, and I want that evidence before I make a ruling. So I'll take it under, I'm going to deny it, take it under advisement. It really doesn't matter. It's the same consequence. I'm going to wait and hear stuff. So go ahead.
All right. Then the standard will call Michael Schlager to the stand.
All right, Mr. Schlager, would you please turn on your camera and press 5* one time on your phone? Mr. Schlager, good morning or good afternoon, depending upon where you are. Would you raise your right hand, please?
Good morning, Your Honor.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead, please. Mr. Campbell.
Mr. Schlager, can you please introduce yourself to the court?
Yeah, my name is Michael Schlager. I'm a managing director at PJT Partners in the Restructuring and Special Situations Group.
And Mr. Schlager, can you briefly describe PJT's role in this case?
PJT Partners is the investment banker to the debtors in these cases.
Can you describe your personal educational background?
Sure. I graduated from Cornell in 2004 with a major in economics and a minor in French area studies. And I attended Columbia Business School, graduating there in 2010 and ended.
Can you describe your professional background prior to joining PJT?
I started my career at Bank of America Securities in 2004, the investment banking group, and then joined Lazard, and then Lazard into business school. After business school in 2010, I joined Blackstone, and then at Blackstone and then PJT through the spin-off in 2015 for the past close to 13 years.
Can you describe, in general terms, your roles and responsibilities as a managing director at PJT?
Yeah, so they're broad, but they include, among other things, leading day-to-day transaction execution on both in-court restructuring that's in Cineworld as well as out-of-court, restructuring, liability management transactions, and then the extends, stress financing, and as part of that, we frequently will perform valuation analyses.
Can you describe, at a high level, your experience with conducting going concern valuations of companies?
So, in connection with advising debtors, performing a number of valuation analyses in context of a plan, performing a number of valuations advising creditors, and then just as a restructuring advisor, much of the advice that we give to our clients is found in some sense of valuation, so naturally frequently perform valuations.
Can you describe your role specifically in this case, in the Cineworld case?
Yeah, so I've been leading under Steve Bellin, who runs the practice and runs this deal team, really day-to-day transaction execution, anything from raising a $1 billion non-debt facility at the onset of these cases to negotiating the restructuring support agreements, overseeing the marketing process that is run by our advisory group, and also overseeing the exit financing process that's being conducted by our capital markets group, as well as the valuation that's performed in connection with the plan.
Can you describe your personal level of involvement in the valuation analysis in this case that you just mentioned?
Yeah, I've been highly involved in every aspect of that valuation.
Can you describe the methodologies that were applied in valuing debtors as part of that valuation?
Yeah, so we evaluated really what we refer to as typical valuation methodologies. We looked at precedent transactions, although we ultimately did not rely on them, and I can talk about that a bit later. We looked at
value analysis. We looked at a discounted cash flow analysis, and we also considered the marketing process that was conducted in connection with these Chapter 11 cases for the company as a whole, as well as any other value maximizing transaction, which in this case also included, for example, a sale of the rest of the world business.
At a high level, can you describe the comparable transactions analysis, or why you did not consider the comparable transactions analysis?
I did not consider the precedent transaction analysis. I did consider the comparable transaction.
I conflated the two, the precedent transaction.
Yes, I did not consider the precedent transaction analysis because there have been no recent transactions in the sector, and all of the transactions that have been effectuated were pre-COVID, which was at a time when the outlook for the industry was significantly materially different than what it is today.
At a high level, can you describe the comparable companies analysis that you conducted as part of the evaluation?
Yeah, we observed the market prices of comparable companies and looked at the multiple at which those traded over the course of a period, and then applying those to Cineworld's relevant metrics, which in our case included a combination of an EBITDA multiple, which is multiple where the EBITDA is burdened by lease expense, and an EBITDA multiple where the EBITDA figure is not burdened by lease or rent expense. And to the extent we rely on an EBITDA multiple, we made further adjustments because EBITDA is not burdened by rent, EBITDA is burdened by rent, so we made further adjustments so that it's apples and apples to EBITDA multiple methodology.
At a high level, can you describe the discounted cash flow analysis that you performed as part of the evaluation?
Sure. So we derived the unlevered free cash flows over the forecast period, or the unlevered free cash flows, which is premised upon the forecast that was prepared by Alice Partners, and we then discounted those to present time based on the discount rate.
With respect to the cash flows that were considered as part of the discounted cash flow analysis, do future projections that you considered reflect a projected increase in the box office?
That's the
What conclusion did you reach as a result of your valuation analysis with respect to the debtor's going concern enterprise value?
We concluded that the value of the debtors is between $2.8 and $3.4 billion.
Were the results of this analysis included in the debtor's disclosure statement?
Yes.
Do you know what the approximate total of DIP and legacy facility secured debt is for the debtors?
It was approximately $6.2 billion.
And are you aware of approximate ranges of administrative and unsecured claims in this case?
Approximately $1.8 billion to $2.4 billion.
Now, did you conduct or were you involved in a marketing process as part of this case?
I oversaw the marketing process. I did not run the marketing process. The marketing process, as I indicated earlier, was run by our advisory practice.
Can you describe, to the extent you are familiar with it, how the marketing process was conducted?
Yeah, absolutely. We reached out to approximately 40 parties, combination of strategic and financial parties in the beginning of January for, again, the sale of the company as a whole or any other alternative value maximizing transaction, which included the rest of the world. Initial bids were due in the middle of February. We received a total of 6 bids, 2 bids for the company as a whole, or the legal business, the U.S. business, and then 4 bids for the rest of the world. We knew that 4 parties that submitted bids for the rest of the world to phase 2 of the process, and at the conclusion of that process, we received 3 bids, and ultimately did not transact on any of those bids because we did not meet the valuation expectations of stakeholders. As it relates to the Orco or Rico transaction, we ultimately did not move them on to be one of the transaction because their bids were effectively non-cash merger proposals, and the valuation did not meet the expectations of the lenders. So therefore, we did not advance the buyers in connection with the whole Rico business.
In connection with the marketing process, did the debtors receive any bids that either on a cash or non-cash basis would have valued the debtors in excess of their existing debt and legacy secured facility debt claims?
No.
Your Honor, I have no further questions, Mr. Shaw.
Thank you. Mr. Sather.
Mr. Schlotweg, you're not an industry expert in the movie business, are you, sir?
I'm not.
And so, what weight did you put in your analysis on the trends in the movie industry today?
That trend, that recovery is reflected in the forecast, which was reflected in the trading cost analysis as well as the DCF analysis, and frankly will also been reflected as part of the marketing process because we shared the forecast with those parties and they clearly could see the recovery curve in the industry.
All right. And so we know that there is a recovery going on in the movie industry, correct?
Yes.
And would you agree with me that this debtor was solvent prior to the COVID pandemic?
Yes.
And now, in terms of your analysis, all we have to look at is a 4-page summary that's been included in the disclosure statement. Isn't that correct?
As it relates to our valuation analysis, yes.
And so,
presumably with other information that
sure.
presumably there's other information available in the public domain for your client to rely on that information.
However, if we were to get under the hood and look at the nuts and bolts of your analysis, the members of the public don't have access to that data, do they?
It depends on what you mean by that data. If there is a significant amount of data available in the public domain, including a forecast through 2027, in great detail by geographic groupings that should form the baseline of any valuation analysis.
Right. But we don't have your actual valuation other than a 4-page summary, do we, sir?
That's correct.
Now, would you agree with me that one of the best ways to value a company is what players in the market perceive?
Do you mind explaining what that means?
Oh, certainly. I apologize if I was inexact. But when you're looking at a publicly traded company, isn't the trading in the stock relevant to how the marketplace values the company?
Are you asking whether looking at trading comps is a relevant valuation methodology?
A relevant factor, sir.
Yes, absolutely.
And you're aware that Cineworld was publicly traded prior to the bankruptcy being filed, correct?
Yes,
And has continued to be traded throughout the period of the bankruptcy.
that's my understanding.
And so, would you agree with me that the fact that there is active trading in the stock is an indication that participants in the market perceive there to be value to the debtor enterprise beyond the debts?
I'm not sure that suggests there's value one way or another.
Okay. But you would agree with me that when people buy and sell stock, they're making a judgment as to the value of the enterprise, correct?
The value of the stock that they are purchasing and selling.
Sure. Now, would you agree with me that people in your profession sometimes disagree with each other?
Yes,
And so, where you came up with a value of $2.8 to $3.4 billion, another qualified professional could come up with a higher or lower valuation, correct?
within a band, yes.
I'll pass the witness, Your Honor.
Thank you. Anything further?
Just a one redirect question, Your Honor.
Go ahead.
Mr. Swalka, do you believe that any generally accepted or reliable valuation methodology would value this company above the value of the existing debt and secured legacy facility debt?
I do not.
No further questions, Your Honor.
Mr. Sather, anything else?
No, Your Honor.
Thank you. Any further evidence by any party?
Nothing from the debtors, Your Honor.
Not from the committee, Your Honor.
Thank you. All right, what I have before me is a motion to authorize or direct the appointment of an equity security holders committee. I'm going to deny the motion today, and I'm going to reconsider the motion next week if the committee determines to file such a motion with the appropriate attachment, which I'll describe in a moment. The evidence today reflects that the debtor has no chance of having enough value to pay unsecured creditors in the near term. Excuse me. I'm going to interrupt my findings. Mr. Lohan, go ahead. Hold on.
Question for Mr. Black.
Mr. Lohan, go ahead.
Your Honor, I don't want to interrupt your findings. I had a question back for Mr. Schlappich at the end, but I think we can go forward with your findings.
I just didn't see you on time. If you want to ask him, I'm going to allow you to ask him. If you want to pass on that, that's fine.
I think you're touching on it in your findings, Your Honor, so I don't think you're going to that.
Thank you. There is no chance, based on the testimony before me, particularly the testimony by Mr. Schlappig, that the debtor presently has sufficient value to pay any return to the shareholders in the case. The only conceivable way, based on the evidence that is before me, that anything could occur is if there was a forecast recovery of which the shareholders could somehow take advantage. I have no evidence before me that such a forecast recovery would allow the debtors to take advantage of that. And as I indicated at the beginning of the case, that would mean that there would have to be some sort of a plan that would carry the existing approximately $8 billion worth of debt into the future long enough that the debtor would somehow return to solvency. And right now, there is no evidence of that at all. I find the debtor is hopelessly insolvent based on this evidence. This is a company that is worldwide in reach and worldwide in its shareholder pool. Confirmation hearing is set for 12 days from today. Earlier in the case, and I don't remember the exact date, but roughly 2 months ago, held a hearing on a motion by an individual shareholder who wanted to have a creditors committee appointed, gave her the opportunity to come back with evidence, and she chose not to do that. At this stage, believing that we could get a report in that was sufficient to make such a demonstration by the 28th at a reasonable cost seems improbable to me. That said, although I find Mr. Schlappig a completely credible witness in terms of all the valuation issues, I find Mr. Grauman to be a completely credible witness in terms of his own sincerity of trying to get something done here. I think he got impeached reasonably badly by Mr. Campbell with respect to whether there really is someone who would do this at a reasonable cost. I will reconsider this decision. And I'm not saying I will change the decision, Mr. Sather. I don't want you misreading this into being more optimistic than I'm intending it to be. But I will reconsider the decision. If I really had a global firm that could do a meaningful valuation with forecasts that would show either that Mr. Schlappig is completely wrong or that there is a way to recover long-term and a path to get there, and could do all that in time for a confirmation hearing at $150,000 cost. I will say I'm not terribly worried about your attorney's fee costs, Mr. Sather, just because you're right. They will get dwarfed in the case. But if I did have such a report, that's going to cost a huge amount of money to deal with it from the other side. Those are the breaks. But it's not worth it if I don't even have that report or any even real possibility of it. So, if the committee, the ad hoc committee, wants to pursue this motion with a motion for reconsideration, they can do that, and I will take it under advisement on an emergency basis, but they have to attach to it the identity, the qualifications, the timing, and the Daubert qualifications with respect to the forecast or the valuation that they're going to present. And then I'll rethink about whether what I'm doing is right. I have to say that you may still not prevail, and that's why I'm trying to be cautious about this. I'm not just trying to put you through your paces. I want you to think about how much sense it'll make given the evidence that I have. It may be worth quitting, but I'm trying to respect. I have a lot of shareholders out there, and I want to be sure the process is fair. So we'll see if we can get that done. I'm not going to continue the 28th hearing, certainly on the evidence that we have, and you've not asked me to, and I respect that. But the evidence right now that I will have anything competitive really doesn't exist. So that's why I want to at least think about this again next week. If you file such an emergency motion, please include Mr. Campbell on the email seeking an emergency consideration of it. Notify Mr. Laws. I'll have it brought into me right away, and I'll reconsider whether this decision is correct. But for today, the motion is denied. Is there anything else that we need to do on the docket today? I want to make one more finding, and I'm sorry, I meant to make this earlier. Part of the reason why I'm giving more attention to this is that Mr. Grauman chose to hire your firm, Mr. Sather, and he may not know, but he's hired one of the leading Texas bankruptcy law firms to do this. And so I place some confidence that Mr. Sather will exercise appropriate professional judgment as to whether it's worth filing that motion for reconsideration. but he starts with the benefit of the doubt. And so that's where we are. And I think it's worth noting for any appellate record that I don't have somebody that's coming in and asking me to do this that doesn't know what they're doing. Mr. Sather knows what he's doing, and he also will respect the process. So the motion's denied. We'll reconsider it if appropriate next week. Ms. Whitworth, go ahead, please.
Good morning, Judges. Again, Whitworth on behalf of the United States Trustee. Your Honor, I just wanted to make a statement on the record for all parties involved. The U.S. Trustee is taking into consideration all of the evidence that has been provided, and we stand ready to comply with any orders the judge in this specific court enters.
Thank you, Ms. Whitworth. And of course, I'm not precluding you from deciding on your own that you're going to appoint an equity committee. That is U.S. Trustee's decision. I have the authority to require you to do that, and I'm not today issuing that requirement. I'm not precluding you from doing it. If you disagree with my view of the evidence, y'all make your decision that you think is best.
Yes, sir. I just wanted to let you know, we saw all the things that were filed in response, and I need to go back to my client with the evidence that was in there today. So I just want to let the court know that we are reviewing all of that. We did not follow the response because we didn't have the information when our following the proceedings closed.
Okay. Thank you very much. We are in recess.
Thank you, Your Honor.
Thank you.